Next up, HB 1301, Parsons-Mulicka, Parenting and Time Sharing of Minor Children. You are recognized to explain your bill.
Thank you, Mr. Chair. Good morning, Mr. Chair, Vice Chair, Madam Ranking Member, members. It's a pleasure to be before you today to present House Bill 1301, Parenting and Time Sharing of Minor Children. Members, this bill amends certain provisions within Chapter 61 of Florida statutes that govern matters relating to parenting plans, including time-sharing schedules of minor children. This bill builds upon our work in the legislature to stand up for Florida's families and children. It acknowledges the invaluable role that both parents play in a child's life. Study after study has shown that our kiddos do best when both parents are involved in their lives. However, 1 in 4 American children still live in a home without a father figure. In addition, we see and hear too many stories of families being torn apart in court over custody battles. This bill seeks to encourage both parents to be involved in their child's life and reach an agreement that is best for their child outside of adversarial litigation. This bill creates a presumption that equal time sharing, 50-50, is in the best interest of a minor child unless otherwise agreed to by the parties. This means that when parents walk into court, they do so from a place of fairness and balance on equal footing. Members, this does not mean that they walk out of court on equal footing. This bill does not change the requirement that the primary consideration be the best interest of the child. The judge must still go through 20 listed factors in statute, and the judge has the final determination on what is best for the child. The bill also creates a presumption that when a parent relocates within 50 miles of the child, that such relocation is a substantial and material change to permit the court to consider a modification to the parenting plan and time-sharing schedule. Any modification, however, is still subject to a review of the same 20 factors listed in statute, and the primary consideration remains the best interest of the child. Members, that is the bill.
Members, any questions on this bill? Any questions? Representative Campbell, you're recognized.
Thank you, Mr. Chair, and good morning, Representative. My question is regarding to when there's domestic violence involved, does this now have impact? Does this consider the impact on that?
Representative Parsons-Mulicka, you're recognized.
Thank you, Mr. Chair. Thank you, Representative, for that great question. No, this bill has no impact on how a judge would treat such fact patterns. This bill merely says that when parents walk into court, they walk in under a presumption of fairness, of innocence on equal footing, but the judge has to then consider all the evidence that goes towards those 20 factors. There's different provisions in statute that I'm happy to walk through with you offline, but there's a provision we're not changing that creates a presumption when there's an actual finding of guilt in court order in that case. But even where there is no judgment in such cases, one of the 20 factors, and I'll read that for you, is that the judge is to consider is evidence of domestic violence, sexual violence, child abuse, child abandonment, or child neglect, regardless of whether a prior or pending action relating to those issues has been brought.
Representative Campbell, you're recognized for question.
Thank you, Mr. Chair. And so, like, as regards to 50-50, currently now, isn't that the structure at hand? Where are they starting that from, and how does this make a difference or make a dent in what we're trying to, what you're trying to do with this bill?
Representative Parsons-Mulicka, you're recognized.
Thank you, Mr. Chair. Thank you, Representative. Currently in statute, we expressly state there is no presumption one way or the other. We encourage both parents to be involved, but there's no presumption as to time sharing. And what we have seen in practice is that parents often go into the battle fighting for 100 to 0, or the other way, 0 to, whichever parent's fighting for 100 to 0. We see too many cases where the child is used or weaponized in a dissolution matter, and we need to get back to the focus where the focus is on what's the best interest of the child, and let's start from a presumption of 50-50. It's just a starting point. We've seen in states that have passed such presumption a reduction in cases that actually go into court on an adversarial basis.
Representative Campbell, you recognize.
Thank you, Mr. Chair. Now, would this slow down the process of how these cases are reviewed? Because if we're going in there at 50-50 and say, for instance, the judge sees, hey, this domestic violence going on, or there's something of concerning within the relationship, does that fall back now to have to kind of go back and backtrack to see what's going on before they can move forward and try to talk about time sharing?
Representative Parsons-Mulicka, you recognized.
Thank you, Mr. Chair. Thank you, Representative, for the follow-up. Absolutely not. One of the main reasons, or one of the whys for this bill, is to actually reduce the number of cases that go to court. Let's speed up the process. Let's encourage families, parents, to start talking from a standpoint of, if they know the law is a 50-50 presumption, they can go sit at the table and talk about what's best for their child versus going in and trying to fight for 100.
Further questions? Seeing none. Public testimony. Sebastian Aleksander, waves in support. Josh Heath, Fair Parenting for Florida's Children, waves in support. Philip Wanenberg, Family Law Section of the Florida Bar, wishes to speak. Sir, you're recognized.
Good morning.
Good morning.
I currently serve as a magistrate in the 13th Circuit, and I also serve as this year's chair of the Family Law Section, the 4,000-member body that has brought a lot of good legislation here this session. Unfortunately, this is a bill that we are continuing to work on with the bill sponsor, and we continue to keep working with her to make this a better product. The section has consistently been on record with its opposition to a presumption of equal time sharing in family law cases. And again, today I renew that longstanding opposition. In 2008, the statute on time sharing was amended to remove all presumptions, and the bill sponsor just mentioned that. There are no presumptions right now in the current statute. And the current statute works. It has 20 factors that a judge or a magistrate must consider when deciding time sharing cases. And those factors work. They allow each judge or magistrate to look at the uniqueness of each child, the uniqueness of each parent or parents, the uniqueness of each family. And that allows for a court to properly address what is truly, ultimately most important, which is entering a time-sharing plan that is in the best interest of the child or children at issue. Reading through the staff analysis of the bill that is presented here today, there's a great explanation of how the statute works. It talks about how there are no presumptions, how there are 20 factors a court must consider. What's missing is any mention of why we need to change that foundation, that structure, the way courts are doing it now. It works. We are asking that it continue in that manner. With regard to the provision regarding the relocation, we've had good discussions with Representative Parsons-Mulicka, and we hope to continue those discussions to improve on that language, and we do have good language that we've shared with her, and we're hoping to see that language brought into it. But again, with respect to the presumption, 47 other states do not have such a presumption. Of the 3 that do, their presumption is expressed as a rebuttal presumption. This language does not have that rebuttable term. And so, again, the section finds itself in a position where we cannot support the bill as it's presently worded, but we hope to continue working with the representative to make it a better bill. Thank you.
That's all the public testimony we have for today. Members, we're in debate. Representative Campbell in debate.
Thank you, Mr. Chair. I came in here looking to vote up on this bill. I just have a lot of concerns regarding it, and I guess that's just on my fault in just learning more about what's being presented in front of me. You know, I'm the first one here to say I'm not a lawyer, and so, but I've gained some lawyer skills from being on this committee, and so I appreciate you for bringing this before me. But as me feeling confident to vote on this bill right now, especially after the testimony we just had, I still need to kind of fine-tune and really understand what I'm seeing before me before I can actually feel confident in my yes vote. So it's weird. This is not like a no, typical no for me, but it's something that I need to kind of discuss with you more on and actually learn more on what the defining of presumption and what's currently happening and why do we need this as well. So thank you for reaching out to me, and I look forward to talking with you more about your bill.
Representative Gant, in debate, you're recognized.
Thank you, Mr. Chair. The current structure, as a gentleman from the family law section, works. And if it ain't broke, don't fix it. So I don't see why we're creating a presumption that doesn't have rebuttable. Every family, every situation that comes before a court is unique. And so these 20 factors inform the court as to what they need to look at. It informs the attorneys, and in a case where it's a pro se client, they have the opportunity to have clear language and guidelines as to how they can advocate for themselves without an attorney. And so thank you to the family law section for providing that commentary. And I will not be voting up on this because the current structure does work, and the best interest of the child is what is the utmost importance. So the language that is currently in statute works for children, and it works for the unique circumstances of each family. So I would ask everyone to allow the structure that is currently being operated in our courts to remain in operation. Thank you.
Ranking Member Arrington, you're recognized in debate.
Thank you, Mr. Chair. Good morning, Representative. I am not a lawyer, just like Representative Campbell, or a parent, so this is definitely not my expertise, and I did not see this legislation last year and didn't realize until today, unfortunately, that the family law does oppose it. So today I will not be in support of it, but I would love to get some more background and continue working with the stakeholders, and I'd love to be up on it in the future. Thank you.
Further debate. Representative Parsons-Mulicka, you're recognized to close in your bill.
Thank you. Thank you, Mr. Chair, and thank you, members, for your debate. And I look forward to continuing to having these discussions as the bill continues to move forward. We did pass these measures off the House floor last year as part of a larger alimony reform package. And this year, this bill is so important to me because I have seen examples after examples of this current statutes not working for our families, not working for our children. And that's why I brought the standalone bill this year to fight for our children. Again, 1 in 4 children in America grow up without a father in their house. We can do better. And this is one piece of a larger puzzle, and I look forward to continuing to champion for our Florida families and children, and I ask for your support today. Thank you, Mr. Chair.
Representative Parsons-Mulicka, having closed in her bill, Julia, please call the roll on HB 1301 and announce the vote.
Representatives Arrington.
No.
Beltran.
Yes.
Black.
Yes.
Campbell.
No.
Daniels.
Yes.
Gant.
No.
Lopez.
No.
Maggard.
Yes.
Maney. McFarland has been excused. Michael.
Yes.
Overdorf.
Yes, ma'am.
Rizzo.
Yes.
Roth.
Yes.
Soroy has been excused. Smith. Yes. Snyder.
Yes.
Chair Robinson.
Yes.
11 yeas, 4 nays, Mr. Chair.
Please show HB 1301 reported favorably. Congratulations.